Namaskar. This is Manyata, the convener of VidhiMitra, the legal aid cell of DNLU. I want you to join me in welcoming Mr. Utkarsh Sonkar. Sir is an NLS graduate of 2018 batch as a gold medalist. Furthermore, he had the privilege of working with Justice N.V. Ramanna. Sir also served the judiciary, being a civil judge for 3.5 years, and currently Sir works as an advocate in the High Court of Madhya Pradesh. Sir is renowned for sharing his legal expertise and knowledge with aspiring litigators and students. I want you to join us in welcoming Sir for this legal podcast known as Vidhi Vaani.
So, we begin with the first episode of Vidhi Vaani. I am Sarthak Mishra, a member of VidhiMitra Legal Aid Cell at Dharmashastra National Law University, Jabalpur. I am truly honored to have with us today Mr. Utkarsh Sonkar sir, a distinguished former judge in Madhya Pradesh, to share his insights in today's important topic, which is evolution of law pertaining to rape in India. In the episode of Vidhi Vaani, we are diving into India's most debated and evolving legal topic, which is rape laws. From their historical foundations to landmark cases like Nirbhaya incident, these laws have shaped the pursuit of justice for all survivors in profound ways. But the conversation goes beyond just the past. Over to you, sir. I would like to begin with you giving us a brief overview of historical context of rape laws in India and how these laws have emerged over the time.
Thank you, Sarthak, for the question. This is truly a pertinent topic, and I'm grateful that the Legal Aid Clinic of DNLU is taking it up. As far as rape laws are concerned, if you see it from a historical point of view, you would see a transition in law from a very penile vaginal approach to that of a bodily integrity approach. So when rape laws were actually enacted and codified and made an offense, they imbibed within them a sense of Victorian notions of morality, chastity, and honor, wherein the emphasis wasn't as much as on the women, but on protection of legitimate father's interest. And that's why the laws catered to that particular aspect, because it was a very property-oriented approach. Women were not treated at par with men, and they were supposed to be chattel of men. And that reflected in our laws. Over the course of times, there have been stark changes that have taken place. One of the foundational changes that took place was in 1983. Now, anytime a change takes place, it generally precedes something. Similarly, in 1983, there was a judgment of the Honorable Supreme Court, that is Tukaram versus State of Maharashtra, which actually led to a furor. The incident was such that a victim was raped in police custody, and eventually the Supreme Court ended up acquitting the accused, who were police officers in the case, on the ground that there was lack of physical resistance. So impliedly saying that there was consent in the act. That led to a furor. Eventually the law was amended and it brought in something transformatory. That was a presumption of absence of consent in such matters, because in sexual offenses it becomes really difficult to establish the fact of consent. Therefore, taking into the prevailing societal realities, a presumption was incorporated. In fact, the very way in which we perceive the offense of rape underwent a change. So you would see the chapter which was entitled Rape was amended to state it to sexual offenses. Similarly, there were amendments regarding having an in-camera trial and protection of identity of the victim. So it has now been made an offense that if you disclose the identity of a victim, that amounts to a criminal offense punishable under law. So a protection is accorded wherein the name of the victim is not mud-sledged. Subsequently, an important transition, in my opinion, happened in 2003, because in courtrooms, everything is based on facts and evidence. Now, our law of evidence, having this sense of Victorian notions of morality, had a particular provision, that was section 155 subclause 4, which said that during the deposition of the victim, you can impeach the creditworthiness on the basis of general immoral character of the prosecutrix. So that was done away with it. The entire idea was that if a woman is not chaste, anything can be done to her. So that entire approach has underwent a transition. In 2013, finally, after the unfortunate Nirbhaya incident, we had a fundamental transition in law, wherein this penile vaginal approach to the law was done away with, and an approach of women's bodily integrity has been incorporated, and that is quite apparent from the amended definition itself.
Thank you for the detailed historical overview, sir. It's fascinating to see how the legal frameworks has changed. Another issue that often comes up is the fear of false accusation in rape cases. How does the law balance the need to survive while ensuring the law is not misused?
Law always has inherent built-in mechanisms to ensure that it is not abused. One of the provisions regarding that is prompt recording of audio-video statement of the prosecutrix before a judge. Now, this does two things. Not only does it pin the prosecutrix to the statement which she has given, and eventually she cannot turn around against it because it would lead to perjury, it also ensures that whatever actually transpired is brought to the fore before the court. So the apprehension that there may be false accusations also get watered down because of this provision.
That's a crucial point, sir. What further needs to be done to address this issue effectively?
Law has adequately ensured that the definition of consent has now become that of a free, unequivocal agreement. However, as you said, things do not stop there. There are certain crucial aspects in that offense of rape which are still not perceived in our country. And they are, first, the issue of male rape, and second is the issue of marital rape. Male rape, you would see as a concept, is not alien to our jurisprudence. In fact, 172nd Law Commission of India report suggested that we make the offense of rape molded in a gender-neutral term. However, that has not been incorporated till date. There are other jurisdictions which have already done it. Similarly, we come to the question of marital rape in the country. It's hotly debated. In fact, we are running really back in time because we have still not done it. Poland, which was the first country to have done it, did it way back in 1932. The erstwhile Soviet Union ended up doing it in 1960. And even in our neighborhood, Nepal has criminalized marital rape way back in 2006. So we are really running behind the clock in doing that. But that's because of the myriad problems that are alleged to be prevailing in criminalizing the offense of marital rape. And it is unfortunate to actually see that most of the objections which are put against criminalizing marital rape are completely ill-founded. So one of the major reasons, Sarthak, that you would see behind non-criminalization of marital rape is the implied consent theory. And this was propounded by Sir Matthew Hale way back in 1736. So implied consent theory virtually says that in common law, we deem husband and wife as one entity. So if it is one entity, it cannot consent against the another. So this is again rooted in the idea that women is virtually property of a man and does not have a separate entity of its own, and she is completely devoid of any sexual agency or initiative on her own. This is one of the major challenges that we face in the context of marital rape. As far as criminalizing the same in today's context is considered, we would see that there are beacons of hope, because in the erstwhile IPC, when we had section 375, it provided that if your wife is below the age of 15, then if you commit the offense on her, then you won't get this exception or the protection that marital rape is not criminalized in our country yet. However, the Honorable Apex Court of the country stepped into the picture in Independent Thought versus Union of India and actually read down that age qualification to harmonize it with the provisions of the Protection of Children from Sexual Offences Act, wherein they raised that bar from 15 years to 18 years. to state that that particular age requirement has to be 18 so as to bring it at par with the POCSO arrangement. It is good to see that that has now been incorporated in the new law, that is the Bharatiya Nyaya Sanhita that we have.
It's noteworthy to observe that some prominent women holding powerful political position have expressed opposition to the marital rape. Could you shed the light on the reasons behind this?
This is quite a pertinent question because in feminist literature, whenever we are analyzing anything from a feminist point of view, the idea is that we should be asking the women's question. Now, it is ironical that I'm actually addressing you today on marital rape, but being a man, I would still try to ask the women's question in this particular aspect. Now, the idea is that we believe that when someone who has experience of a particular aspect comes to a position of power, they will actually be more empathetic to that issue. Hence, the question as to why women who are in prominent political positions are staunch opposers of the issue of marital rape. We cannot lose sight of the fact that we are in fact socialized by the society in which we are living in. So if our society has deep patriarchal norms imbibed within it, we tend to absorb them as well at the end of the day. And hence, the problem of false consciousness that comes into the picture. The problem of false consciousness essentially is that though you may be a woman yourself, but because you have been socialized in a society full of patriarchal norms, at a particular point of time, you are unable to look beyond that particular lens. And perhaps this is the reason why some of the prominent political figures in the country are staunch opposers of criminalization of marital rape in the country.
It's interesting to hear your perspective, sir. Additionally, what measures do you think should be in place to protect survivors during the trial process, ensuring their dignity and mental well-being throughout the ordeal?
An issue of rape traverses beyond the physical bounds. It's a psychological attack on an individual. So during the trial process, the idea should be to minimize the number of times the victim has to go through it again, not to recur it again and again in their memory. One of the major ways by which that can be achieved is by ensuring that the trial process is completed within a definite time-bound period. And we already have fast-track courts which are dealing with sexual offenses. However, considering the docket explosion in our country, taking matters to their logical conclusion still takes time, but it's a work in progress and law is definitely cognizant of this particular aspect.
Thank you so much, sir, for highlighting those protections. Sir, it's often said that criminalization of marital rape would lead to the disintegration of moral fabric. How do you overcome this?
That's a fairly interesting question. And actually, it reminds me of the Hart-Devlin debate that we have read in jurisprudence. Now, Hart-Devlin debate came in the context of criminalization of homosexuality. Now, Mr. Patrick Devlin was against the very idea of homosexuality and wanted to criminalize it. And one of the grounds that he had taken was that if homosexuality is not criminalized and if it is allowed to be perpetuated in the society, it would lead to disintegration of the very moral fabric of the society. And as a society, we would then disintegrate and it will cause anarchy. Now, this was countered by Professor H.L.A. Hart, who said that moral fabric of the society is not something which is static in nature. We grow over the course of time. We are an organic society. And so our morality also changes over the course of times. What may be moral today may become immoral a day later. And thus, we have to be cognizant of these particular realities. Now, as far as seeing marital context from the lens of moral fabric of the society, I believe after the advent of the Constitution of India, men, women, and all persons have been guaranteed the right to equality. And thus, their bodily integrity has to be respected, be it beyond the bounds of marriage or be it within the bounds of marriage. Therefore, if an offense happens even within the realm of the marriage, it still remains an offense. So we have to criminalize it. And in fact, criminalization would, instead of disintegrating the moral fabric of the society, would rather reinforce it, in my opinion, because then there would be mutual respect for the genders, mutual respect for the partners, and a healthy relationship.
Thank you so much, sir, for your insights. As we conclude today's discussion on evolution and current state of rape laws in India, it's clear that while legal reforms have made significant strides, there is still a long way to go. Beside the legal reform, what we actually need is cultural transformation, one that respects consent, one upholds the dignity of survivors, ensures swift and justice for all. A hearty thanks to Sir for sharing his invaluable insights on such a crucial issue. Your perspective has greatly enriched our understanding on the challenges and complexities of rape laws in India, and also highlighted the path for further reforms. To our listeners, thank you for tuning in. Stay tuned for episode 2.